Another witness?
Your Honor, we do not have any other witnesses, and we have argument for the court.
Okay. Let's go ahead then.
Your Honor, what I'd like to do is I'd like to start with Ms. Nassa. She's going to cover one of the requests specific to the grand jury subpoenas, and then I'll cover the rest of this morning's.
Come on, Lenny.
Okay, thank you.
For those who just joined us, this is the Bryan Kohberger hearing.
Your Honor, to facilitate this argument on this point, I am going to hand you defense exhibits A and B that were submitted.
Shout out to Lo and
for
Karan.
today. I want you to be able to look at them while I'm talking.
Thank you.
As of today, there have been at least 50 federal grand jury subpoenas that have been issued in this case. Exhibits A and Exhibits B are an example of copies of grand jury subpoenas that we have received out of those more than 50. And what I didn't provide to you that goes behind that what we got with those is the subpoenas include Attachment A, which explains what is being subpoenaed. And then what has been produced is the responses to those subpoenas. And in some of the subpoenas, we also have the certification by the person who has produced the records in response to the subpoena. Some of them are missing. We have asked the state to produce all of the subpoenas. And their response is that they are not in possession and control of those subpoenas, and they do not intend to use the subpoenas as an exhibit. And we have not justified why we need those subpoenas, and for those reasons, they are not going to produce them. I'd like to begin by saying that as it relates to any argument that the state is not in possession and control, rather than beat the dead horse on that issue, Idaho Supreme Court came down in 2023 and made it crystal clear that anybody that's acting on behalf of as an agent of the state puts those records in the hands of the state, and they need to produce them. State versus Pendleton, 2003. The other thing is that in terms of the state arguing that they are not going to use a subpoena as an exhibit, that is not in and of itself a defense to not produce a document to us. We have a million reasons why we need to look at documents. We understand that out of the 51 terabytes that have been produced, that not all of that is evidence that's going to be coming for the court or the jury, but it doesn't mean that they aren't material or exculpatory. The subpoenas, based on reviewing the records, are in the hands of basically three agents. There is an FBI forensic agent by the name of forensic accountant, Michael Douglas. There's a special agent, Travis Shirley, and there is another agent, Mary Tyndall. These are the three agents that are receiving the subpoenas, reaching out to the providers that they're serving and asking for the documents. For the court to understand why we need these documents, I want to tell you what we're doing with discovery and timelines. There are more than 100 search warrants in this case. There are more than 50 grand jury subpoenas in this case. You've heard all kinds of information about the probable cause affidavit and the timing of that. Timing in this case for the defense is everything. So we are creating timelines that put in the dates of affidavits of warrants, the information that's received, and the date that it's produced. With subpoenas, when we don't get a copy of the subpoena and all we get is the warrant or is the subpoena return, we don't know the scope of what the state has asked for. We don't know the
and they're supposed to tell you
that the subpoena was served. And in some of them, we don't know that there is a certified return. So we can't take our timeline on warrants and our timeline on the probable cause affidavit and our timeline on everything else that we're putting in there and interlay the subpoena information that the state is getting. And we are desperate to find out the timeline in this case and when the state knew what and when. There's no question that motions to suppress are coming. Motions to suppress are coming on warrants. And whether or not those motions to suppress are based on Frank's material because misrepresentations are made depends on the timeline. So if there's a representation made in a warrant that things happened in a certain way, if we are able to look at the timeline and say, we know that the state knew this when, that gives us an answer on whether or not the suppression issue includes a truthful statement in the affidavit. And if I'm not making sense, I want you to tell me to clarify that. But we need to know the timeline of all of the evidence in this case. And
So why
when
isn't the
state
prosecutors
knew what it knew,
giving them that
or
information?
why certain things were being looked at before Mr. Kohberger's arrest or well into late in the year in 2023 related to the victims, and try to piece together, is that something that the state is still seeking because they're pursuing the alternate suspects that exists in this case? There's so many things that we're trying to understand. So what we're asking you to do is enter an order compelling them to produce the subpoenas. You see that they had at least 2 in their possession that they possess, and it will clarify it for us. And we will be able to create our timeline and put all of these things together and know when and why the state was doing these things. And just to add one other component, you know, you're hearing about cell phone records and cell phone records today being produced on warrants. Well, there were several sets of cell phone records that were produced pursuant to a grand jury subpoena. Still not clear to us why warrant versus subpoena, and they're different providers. And some of it's for phone numbers that we have to figure out who those phone numbers are. But all of this information is critical and material for us to be able to do the case, to do our work in this case. So I would ask that you enter an order to compel, and that way the state has the ability to take that to the FBI agents and say, the court has entered an order, we've got to produce the subpoenas, and we'll get the subpoenas.
That's
To
right.
the extent that the state may stand up and say, you know, we've got this TUI demands, we've got to deal with TUI. I just want to make it really clear for the court that TUI's not an obstacle. TUI's a hoop to jump through. The code related to 28 CFR 16.21 specifically states that the purpose of TUI is not to prevent federal agents from giving states discovery in a criminal case. Purpose of TUI is because these federal departments want to know when certain records are leaving their files. Understandable, but it's not meant to keep us from getting records that we need in this case.
Thank you. Response?
Well, simply put, we can't give over what we don't have. And we do not have the majority of these subpoenas. What we do have, we've turned over. I reached out to the U.S. Attorney's Office. They advised they're not going to provide.
What? Why?
Because they don't provide subpoenas. You know, just like most grand jury material, it's sealed and not typically provided.
Not typically.
Not provided.
But even with a TUI letter, that wouldn't give it. Would provide. They wouldn't follow that.
We have not, I'm not sure. But beyond that though, even if they were to provide it, I still don't understand how this moves the needle one way or the other. You can tell I detailed there's 71 federal grand jury subpoenas. And in my response, I detailed exactly what they were for and what records were received so that you can get the scope of what was requested from the actual records. The piece of paper that was given over saying, give us these records, is all they're asking for. But they have the records. They have the important part of this.
So they have the timing based on the subpoenas
Off of
that
the
you
records.
provided to the defense.
Off of the records provided. You can tell the scope as well as what they're for. And I've detailed exactly what they were for, and the scope, in my response.
She ain't said nothing.
Any response?
Judge, I wouldn't be wasting the court's time asking for this if the questions were answered based on the state's response to our request for discovery. Timing is critical on when a subpoena is served,
Look at Bryan.
what was the scope, then we can look at the documents to see if they are actually responsive to the scope. And knowing the timing of when that was served versus when it's produced to us is different. And again, I mentioned some of these things are pre-arrest of Mr. Kohberger, and some of it is in the middle, and some of it is, frankly, months after the fact, if not a year after the fact, where they're looking for things related to the victims. And
Can I ask a question? Because Ms. Jennings just said that, that the dates, well, all the subpoenas that were provided to you, 71 subpoenas, and each one of those had the scope of what the request was in the subpoena, and that it would be dated. No?
that's not true.
That's not.
That's not true. No. There are all kinds of different records and different methods that the people that were, the businesses and the people that were asked to produce the records, produce them in different form. I do not know when they received the subpoena, the timing of it, and I do not know for all of these what was the scope of what was asked for versus what was produced. I do know what's produced, but I don't know the timing. And the answer of the date discovery provided, which is in Exhibit 1, that the date that the discovery is provided to us doesn't answer the first two questions that I have, which is the timing of when they asked for it and the scope that was stated in the subpoena of what they asked for. Some companies were asked probably for a certain number of months, and they didn't have records that were responsive to those number of months, right? Because when the state's doing this investigation, they're not necessarily knowing exactly what records exist. So being able to be specific is important. And I want to touch on this issue of it. It's not in their possession. I get that. But you have complete control over what evidence is going to be coming into this case.
That's right.
Your
That's
orders.
right.
You make it crystal clear. Produce it, or it's not coming in. That's the first level of sanction. And then we can just get going from there. Something that's destroyed, you can't produce that, there's going to be a spoliation instruction. Something that we keep repeatedly asking for and it gets past time, we're going to knock the death penalty off the table. You have control to get these issues that we're struggling with fixed by saying, this is my order, produce it, or there's going to be a sanction.
You may be overestimating my power.
I think you're underestimating your power.
I have a good sense of where my power starts and ends. So I don't know. I mean,
You don't know. You the judge.
Discovery that has been
To me,
shared.
like you don't know.
Are all of these 71 subpoenas, have they been provided to me at this point? Because I don't think I've seen them.
They went through a federal grand jury. So this, we haven't seen anything in terms of grand jury testimony, transcripts. What I have surmised based on my federal practice, 'cause I
Y'all
spend
got
about
to show the
50% of my time in
man.
federal court, is that they
Come
use the
on.
federal grand jury as an investigative tool because the FBI is partnering with them. That makes complete sense. These subpoenas are in the hands of the 3 agents that I gave you the names of. They haven't come through you. They're in the hands of the agents. And so it's a matter of them just gathering the records that those agents have in their possession and providing to us. And it helps us create this timeline in a case where discovery is being given to us as if we're living in a snow
right.
globe and it's just swirling around us and we're constantly having to put it together. So, you've asked us several times, what can I do to help you guys get your work done? This is one of those things. Let us see the subpoenas so we can overlay this in our timeline.
Yeah, they supposed
You
to.
just want the subpoenas. You don't necessarily are going to get the response.
We have the responses. We have the records. But what the records don't tell us is what was in the subpoena. It's like a warrant return. What is a warrant based on? It's based on an affidavit.
So
Right.
this is what you want, the paper that says,
And the
this is
exhibit.
what we want.
And the Exhibit A that's attached to that, which I didn't give you a copy of Exhibit A, but Exhibit A is attached to each one of those, and then it specifies to the company, you're looking for phone numbers that are this, and this for these dates.
That doesn't have the date on it when
In
it was served?
those subpoenas tell us, we know when they are served, because it comes back with a date on it. And then,
Right.
and then the attachment A has the scope of what they've asked for. What we've gotten is the documents without, it's like not having the affidavit to the warrant return.
Okay.
So, in other words, what she trying to say, on the subpoenas that they showed them, there are still information not even adding up to where they got that information from. I guess that's what she's saying. Let's move on, y'all. I'm gonna skip Taylor. Let's go to Taylor.
It's provided on a lot of these,
Right.
but on the ones we're missing, we can attempt to inquire and find out the date that it was served, and we can still do that without providing the piece of paper.
Well, besides the timing, what's the relevance to this this scope that was requested?
What's the relevance?
Yeah.
We're not relying on any of these.
I know, I don't think what do you think they think is relevant?
Yeah, for sure.
Okay. You're constantly this. So what is the relevance? But aside with the timing, okay, and the scope.
Judge, I'm not gonna give you the specific date right now in open court on one of the subpoenas, but they used a subpoena to get one of the most critical pieces of evidence in this case. And they know that,
Okay.
and they are gonna use that.
It's something that I don't know about.
Well, I
She
mean,
don't-
you
He don't know if they're gonna
You
use
do
it or
know
not.
it.
Okay, y'all, let me
It's in the
skip it.
probable cause affidavit.
Okay.
Okay, but that's different.
Full for all of the hours and days in question with both audio and video on 510. So we can mark 2A, item 219 off of our list.
219.
219.
And there, I've gone through pages and pages and pages, so I think I really appreciate you being very specific about, what you have now and what you will still.
Okay. Good, because it's the only way I can keep track of it.
Yeah, well, same here. Thank you.
You're welcome. Your Honor, item 2B in our fourth motion to compel is item 224. That's the cast biz law. And this one is rough. The court heard last week Detective Mowry say I don't have any
You
of
sure
those,
did.
except I found these
Sure
other
did.
items that we'll give you now, which were not Mallory's past biz logs. The hard part for us about this one, Judge, and I have to make a record, I think you can order them to double check, and I'm gonna ask you to order them to double check, but the hard part of this for me is that on January 9th, we asked for these cast biz logs. And the response was, from the state, was cast biz does not produce logs. And that's just not true. It does, it's capable, it produces logs. You've heard that in the testimony. Then we filed our motion to compel and explained we have an expert, we know it produces logs, we're gonna bring them. And the response was the working files were not saved. We received that response on April 23rd, 2024. And then on May 10th, we got a little bit more explanation about default settings were used and optional session files were not uploaded. This is really, really difficult because of the varying answers that we've received. The court's heard testimony from Mr. Ray about how important these logs are to know what was done. This is really challenging. We can't recreate what detective.
When they expect to be finished?
I don't have a final time frame. They originally told us it was projected to be completed by June, next month. So I'm hoping to get it within the next month.
All right, thank you. Appreciate that. Sometimes it's easier just to sort a particular issue at the same time.
So the hot ones, it might be, Your Honor.
Yeah.
Your Honor, I do think we have the regional tower list now, so I think we're good with that. On item number 244 and 245, we have those documents now, so we're good there. Moving then to item 248. This is the drive test data, the mapping data. The court heard pretty extensively that we've received this in two places. We received some early on, and then we received a lot more recently, but it appears to still be missing some. Asking the court just to order that we receive the entirety of all drive test data that was conducted by Agent Balance or anybody from the FBI.
Item 219, we've already complied with. The cash biz log. You heard the testimony, and what we know and what the judge heard testimony for is that CASBIZ is just a software program that allows investigators to put in like the records received from a cell phone provider like AT&T into a software program and they kind of visualize. Detective Mallory testified he got the raw data set from AT&T, used the default settings for the times in question. It produced a map. He took a screenshot of that map. We provided that screenshot. He only did this in response to our request to provide a visual for the grand jury. We've been told that optional session files were not created or saved, and that this item just simply doesn't exist. In the current version of CASBIZ, the user settings aren't automatically saved in an exported session, but instead it just returns to default settings. I asked Detective Mallory about this. He advised us that he used the default settings. It doesn't take much time or effort to redo this, which is why he didn't save those logs. That's his normal practice.
This is where the business said they already had given over their videos, and Ampersand and One World Cafe are both listed on that as well. So they were given to somebody to go to Moscow Police Department at some point in time. And that's it for clarifications for me. Thank you.
Great, excellent. Anything else?
No.
Okay, great.
He
All
said
right.
great.
A lot of work there for all of you, maybe a lot, but why don't we take a break? And we're supposed to start.
All right, y'all. That was the end of that hearing. That was Idaho students versus IDV Bryan Kohberger hearing. And what the just a little tiny summary. What defense is saying that the state has subpoenas a lot of people to come to court, and they didn't give them all the information inside of the subpoenas. They feel that they are hiding something from them, in which they could until the trial start, but they can't do that. They supposed to let them know. You know what I mean? So y'all tell me what y'all think about not me, but this hearing right here, okay? All right, y'all, I'm out of here.